You are listening to the Bell Post.
Welcome back to the Bell Post. On this episode, we have a look back over this legislative session that we had this year and looking specifically at bail issues. We did this for the first time 2 years ago, where we had a review of the legislative session. So this is our second time. You would think it would probably go a lot smoother, but I'm not sure it will, just because we know each other so well. We're probably giving each other just as hard a time as anything else.
Yeah, we're
But
already late.
but before we start, when we go to the legislative session, that is a costly endeavor. And when people go to our school, the profits from the school go to fund our lobbyist efforts and our going to the legislative session. And also when you join PBT, those funds are used to also fund our lobbying efforts. And we have a very good reputation at the legislature for having a very strong lobby. And we couldn't go any further without acknowledging that all of that is not enough. And we have to partner with insurance companies or anyone that will help us. And, this legislative session, we had several of our surety companies partner with PBT for the legislative session. Those included AIA, Allegheny, Bankers, American Surety, Financial Casualty and Surety Company, and Lexington. I know that Scott is a agent for one of those insurance companies, and so is Cory. And what I always say at our school when we talk about this is, if you are a member or an agent for a surety company that we have not listed, I would just encourage you to reach out to them and ask them why they are not partnering with PBT to defend the bail industry, which we work almost around the clock to do. So let's get started. So when we talk about this legislative session, what was different this time? Scott?
The politics had lots of outside political forces. Obviously, bail was not one of the major topics. It was down the list of priority items for the governor. You had THC, obviously the illegal alien issue, and many other topics that take up a lot of oxygen during 140 days of the legislative session.
Well, Scott was our past chairman of the legislative committee for PBT, and Cory was our new incoming legislative committee chair. Cory, how would you describe this legislative session?
Honestly, I think it was great that being my first session to be legislative chair, it wasn't as productive, so to speak, for us. We weren't, like Scott said, on top of the priority list like we've seen in the past. So that was definitely something that was different, because I have been involved with legislation for a long time with you guys. And so one of the things that was different, I think, was we weren't one of the top priorities, because we normally are.
Well, it's kind of funny y'all are saying that. We were one of the priority items listed by the governor. I mean, it'd be better not to be on that list.
That's true. I'm just saying, like what I said earlier, I mean, there is a list, and obviously we were on that list. And it was really clean up from previous years past, with Senator Huffman's legislation over the last two sessions. And obviously we're going to get into those items in just a moment. But it wasn't as heart-wrenching and heart-stopping as it was, before. We'd been down this road before. We kind of knew, going into the session with our work that we did in the interim, the topics that they were going to be focusing on. And so it didn't come as any surprise. It's kind of like, we've been down this road before. We know what we're doing. So we didn't have to rebrand what we were doing from previous sessions.
We have a tight knit group that goes down to the legislature, and when we're hot and heavy in the session, and we're under the spotlight. We're there every week for at least 2 or 3 days. Cory, how was it, seeing that tight knit group working together at the session and really just picking on each other almost relentlessly?
I love it. I think it's a lot of fun. It's a lot of kind of like locker room banter, so to speak, with all of
It
us,
would.
our legislative task force, like I like to call it. Uh, it's a lot of fun. I enjoy it. I really do. It's a lot of work and a lot of sometimes late nights, early mornings. But yeah, it's great. I enjoy it. It's a lot of fun.
I think this session, I think probably maybe I discovered it last session, but this session I discovered that Scott has to have a really cold room, and I don't like a cold room. And so
Ready to go with that?
we would have adjoining rooms. And so I would sneak into his room and turn his air way up, or he would try to sneak into our room and turn the air way down. And so it was really, when you say locker room, it was really kindergarten type
Yeah,
tactics.
very juvenile.
And of course, I loved it.
Yeah.
It was fun.
It was like
So,
we were 15 all over again.
yeah, or younger. We've kind of set up a schedule where before the session starts, when we're getting our annual meeting, we're already working in October, November for the next session. And we've done that for several sessions now where we're having meetings. Cory, you and I were involved in meetings with the governor's office in October before the session even started. Talk about those meetings and whether you felt they were productive.
I like the fact that we are proactive and not reactive.
Mhm.
I have a feeling that maybe long ago we were more reactive of, oh goodness, we have issues we need to deal with. Now we're being more proactive, meeting people ahead of time, letting them know what the issues may be coming up, and let them know who we are, what we do. And we had some great meetings with the governor's office. The lieutenant governor, if you recall, he is UI and Irma maybe, and he said that I looked like that actor or something. So that was we had a lot of good interactions with a lot of people, and meeting with the governor's office was a very informative meeting. Like we had some very good dialogue.
That we went to the governor's office with really a specific goal because we were wanting to. There had been a section of Article 1716 of the Texas Code of Criminal Procedure which had been repealed in a previous legislative session and then got vetoed by the governor. And so we were wanting to show them that we thought that that was a mistake. And so we went in with briefing and we were with a specific request to reevaluate their position. Um, they were very open to talking and they always said, well, we'll run it up the pipe. I don't know if we ever got an affirmative, I mean, an affirmative answer for them because what we were looking for was, hey, if we pass this repealer again, y'all will affirmatively state that you won't repeal it or veto it again. And we never really got that. Although they did give us other advice, which was the equivalent of that. But I think we needed that. Yes, we will not veto a second time to get people, especially under the current climate, to stick their neck out against what the governor had previously done. Don't you agree with that, Scott?
Okay, to yes, we never got complete confirmation that had been quote run up the flagpole. Um, but obviously there was a repealer that did get filed
Mm-hmm.
that had to do with 1716. However, it was with a other laundry list of repealers that we thought, and obviously correctly, it never got a hearing because of those other repealers that were attached to it. But yeah, I mean that's part of what we do in the interim, you know.
But this is the first time that I've kind of thought that people file bills over and over again because that bill had been filed before, and then we went to the author that was carrying that bill in the House and asked them to take it and attach it to another part of the bill. They already knew it had been filed in previous sessions. They already knew it had not had a hearing, and so it just kind of made me think, well, So a lot of these bills are just being filed so they can say that, so they can pump their numbers saying they filed a bill. I mean, I was wondering because they had no intention of having a hearing on them.
It just makes you wonder who they're filing the bill for.
Hmm.
Um, and then, the multitude of times that a particular bill gets filed, yes, is that to placate the party um, that wants it filed, um, and knowing that it's not going to ever see the light of day.
Well, Cory mentioned that we also mentioned with the we also met with the lieutenant governor in getting ready for the session. And I mean, those are difficult meetings to have. I mean, how important it is to get a face-to-face meeting with the lieutenant governor before a session starts? Scott?
I think we PBT has had a very long relationship with the lieutenant governor. That started way back when he was in the House. Actually, before he was in the House, his relationship with a member of our organization at that time, and then when he ran in the House, he had a very good relationship with the association in Harris County. And I think we just fostered that relationship over the years and extended it to his time when he was in the Senate, and on to when he became lieutenant governor. So
But
I
I
think
think
those
all
are
that does is give us a little credibility. I mean, but he had known Cory before this meeting. And when we came in, or when he came in to meet with us, he just looked at Cory and was like, "You look just like," I mean, he knew exactly which actor. He described the
I can't
show.
think of the guy's
We were
name.
all on our phone looking it up. And so, I mean, that was a big part of the meeting. And I mean, it sounds almost silly, but when you can get that kind of connection, so the next time the lieutenant governor sees Cory, he's going to go, "Oh yeah, there's that guy I thought
That's
was an
the guy.
actor." Yeah,
Yeah, sure, sure.
Recognize the face. Yeah.
yeah.
So all those relationships, I mean,
Well,
they're
and
not
I
made
will say this
overnight.
about that meeting as well. One of the things I remember for that meeting is when he came in, he's like, "I think I just got a text, or I got a text about you earlier today, Ken." And I'm
Yeah.
like, "What?" Or he asked me, "Did I get a text from you?" And I'm like, "No, I know for a fact you didn't get a text from me." And he's like, "Well, I think I got a text about you." And he looked on his phone. He says, "Yeah, here's someone saying I'm going to meet with you, and you are a good guy.
Yeah.
You are the guy, and I'm for bail." And I was like, wow. I mean, when you have other people saying, "Listen to this person," and the lieutenant governor listens to them, I mean, that's worth its weight in gold, isn't it?
Oh, I think relationships are a big thing.
Yeah.
I mean, if you've got that relationship with someone that is able to text him just on a whim, hey, you're meeting a guy that I know that's a good guy, that's got you a good foot in the door right there already, right?
Hmm.
I mean,
Um,
it's what we preach to our membership.
Absolutely.
Politics is relationships.
Well, and I keep
Um,
saying every part about our business is personal relationships. I mean, our relationships with the jail, our relationships with our defendants, our relationships at the legislature. Every part of our business is a personal relationship business. Um,
Absolutely.
let's talk about the House. It's kind of hard before the session starts to know who to talk to. I mean, you don't even know this session who was going to be the speaker. I mean, we knew there was going to be a fight, but because Phelan announced he wasn't going to run for speaker after he'd said he was, and at the very last minute, or weeks before, or sometime before the session started, he dropped out. How does a fight over speaker impact uh, what we're going to do in the House at the beginning of the session or before the session starts? Scott?
um, well, obviously, the previous Speaker Phelan, had been there a couple sessions. We've been able to get in and have some discussions with him. So you're kind of holding your breath a little bit, because you might have someone running that we've not had a relationship with before. Um, Fortunately, the two individuals that ran for speaker, we you know, had some relationships or knew people in our industry that had relationships, with them. Um, I mean, we try as an organization not to get involved in speakers races in general. Um, I think just we kind of stay out of the way of friendly fire, so to speak. 'Cause you can't just pick one. Because if you pick one and they lose, then you're already in the doghouse. So we always throw our support to both, not financially, of course, but verbally.
Well, Cory, what was your impression before the session started? Do you think there were things we could have done better? I mean, and also talk about, we have lobbyists that we use and some of them we've used for quite a while. And, talk about how important they are to getting us in the door to talk to somebody.
Oh wow, yeah, it's PBT does a really good job of working with our lobbyists, working together and trying to get our foot in the door with all sorts of representatives, just to be proactive. Like I said earlier, which is very important. But yeah, it was great this year, I think, because once again, like you said, we were meeting back in what, October,
Mhm.
well before the session started. Our idea was, let's get in and start talking to people, because we know we're going to be somewhere on the spectrum when it comes down to legislation. We're always going to be there. There's so much talk about bail, the bail industry, cash bail, which a lot of people don't understand what all that is. But it is very important for us to get with our lobbyists, to be able to get in the door to talk to certain people. The same way it is to be able to get in with some of our members of PBT or other bondsmen that may not be members that should be, that they can get us in the door to talk to some of those members, that we can be proactive as opposed to reactive. I think that's a big deal for us, is to be able to get in and talk to people and let them know what we do, how we do it, because they don't understand. When we had that meeting with Lieutenant Governor, he was like, "Oh, bail's still an issue.
Oh,
Remember that?"
yeah, that's a
And
good
we're
point.
like, "Yeah, it's a
Yeah,
big
we still have Bell in Texas. That was a comment that the lieutenant governor made, and it may have been
yes."
in jest, but then we had to turn around and point out that according to the latest Office of Court Administration report, we're still 80 something percent, 83% of the releases used in Texas.
And he had no idea.
Hmm.
So that's
Yeah.
very important for us to be involved in that, and people need to realize that.
We have all these meetings. I mean, we go around and meet with Huffman's office. We have a very good relationship with Huffman's office, but also I think at the beginning of the session, before the session starts, we have so many it's like musical chairs. People are shuffling. I mean, we know who the person that's at the speaker's office. We met multiple times with the people at the governor's office. We met the new person at the lieutenant governor's office, and we already have a long-term relationship with Huffman and her staff, where they know who we are. They know our when we're coming in, and they know who to reach out to if they need information. One of the things we've done in the past, and it's really relatively new, is we've prepared notebooks, which we kind of a summary of bail for people that we've kind of used in the last 2 out of 3 sessions. And I've kind of come to the conclusion that those are invaluable. What do you think, Cory?
I think so. We did learn that they're not called white pages anymore. What are they called? Summaries. What do they call them?
One pager.
One pagers. They want to call them one pagers now.
Yeah,
So yeah, it's very important.
we've
And
been
they
doing
do
it so
look
long.
at it.
We were calling it a white paper, and they're like, "Oh, don't use that word anymore."
Yeah, we were outdated.
Yeah, we're so old.
But yeah, so yeah, it was great because we go in there and we hand them a summary of what the issues are, what's going on, what's coming up, and because they want to go through it. They're what was what 1,500 bills were filed the first day, and these guys have a lot to go over. So you got to think, if you can keep bringing bullet points, give them stuff to look at, and go over it, as opposed to a booklet of a whole bunch of stuff. And that's what you were doing, and that's what we were doing. It was great. So I think that helped out a lot.
Scott, 3 sessions ago was the first time we did that. And a lot of the information that we gave out, I mean, first of all, you wonder if they ever look at it, but then a lot of that information turned out to be in bills.
Well, if I can go back a little bit, Cory just brought up a point about, and you brought up a point earlier about the speaker's race. And I'm sorry, I'm going back on you. Um, the important thing about the speaker's race, and you were talking about the composition of like the Senate committee. I mean, we have the lieutenant governor. We have a pretty good idea of who's going to be on the committees. That's what we don't know when there's a speaker's race and a change in leadership, because we have to go through that whole process of appointees to certain committees, and those can change drastically from one speaker to the next, which leads into our booklets that you pass out. I think when we get into once all committees are assigned, especially in the House, you have to remember that there are a lot of members of those committees, especially with a new committee chairman, and a lot of new members. They don't have a lot of knowledge about the bail industry. Yes, they're all not all, a lot are attorneys. They could be an insurance salesman. They could own real estate. I mean, there's a wide range of things that they are proficient in. Criminal justice may not be one of them. And even though you may be very proficient in the criminal justice system, bail is a very particular niche, so those booklets are imperative, and I really do think they read those. They have specific staff that will are specifically there for criminal justice issues, and they may not know a lot about it. Their chiefs of staff may not know a lot about it, and so I think it's invaluable that we give them a Cliff Notes version of what we do. Obviously, the topics that may be coming up during the session, and how we're going to address them or how they may be addressed. It kind of gives them a cheat sheet going in.
Well, we came into this session, so we had the speaker's race, which that would delay the assignment of committees so we would not know who was going to be on the House committee for criminal jurisprudence, criminal justice, whatever you want to call it, or whatever its name is. And so we're kind of waiting for that to happen. But also because of our meetings, we knew we kind of had some input or ideas, and they started filing bills. We had an idea of what SB 9 was going to look like and what the proposal for bail and was going to look like for this session. And there were some drastic differences. One big difference from last session, and it was, I think, as a result of the work that we did, so that something was taken out of the bill. And I don't know if we want to get a whole bunch of detail about it, but we were, I don't think we realized it when it was first filed that change had been made. And so that was good. I mean, I think that was a result of the work that was being done by our group before the session even started.
That goes back to those relationships.
Yeah. And trusting what we tell them.
Yes.
I mean, to the layman, even criminal justice person, the smallest of changes, as we said to when we met with Chairman Smithy's office, and they were saying, well, we're going to make some changes. And they said, well, they're minor changes.
Yeah. And
I said, well, a minor change that you don't think is that big a deal can be a very major change, just based on a comma or an and or an or a may or a shall. Those are big changes.
Well, and with all the bills filed, you know that Moody has always been pushing for a presumption of personal bonds on all misdemeanor cases. So, we get worried that, well, a minor change they might think would be just adding that to the bill, and that would be nothing. That would be nothing but a huge change, especially when the private industries is doing 83% of releases in Texas, and they might not know that's a huge release, but a huge change. But the point I would make is, the session starts, we have the speaker's race, and we've done all this work before we get there, but we're waiting for assignment of committees to really start the session for us. And that starts by us going around and getting cards, not only from everybody in the House and the Senate, but focusing on our committees. Why do we do that? Cory?
That's a great way to start those relationships. Once again, that's a word I keep bringing up, and I don't know why, but yeah, it's one of those things that we have to keep coming back to meeting these people, letting them know who we are, get a name with a face, and let them know what we do and how things work, and we can have contacts that if something does come up later on down the road, we have this contact of Joe Blow or whoever we can call and say, hey, this is an issue that we have, and can we get a meeting with you?
Well, and we have some great digital tools. So
absolutely,
mass emailers and
the late Charlie
click to dial system. I mean, those are all great tools that we need that information for.
The late Charlie Pickens.
Yeah, as a result of the great work of Charlie Pickens, who recently passed away. Scott?
Well, and it kind of deals with how the landscape of how we work in the legislature has changed so much over the last 20 years. I think we try to focus on personal touch, maybe more than other people. I mean, now that when you go in to see staff, they really want you to just email them.
Yeah.
Just email me, I'm dating myself, white paper, however we want to say it. But it's important for us that once we email that information, we go by and make sure that they got it and hand them another, our piece of paper.
Cory, Scott's been doing this so long that when he started, he had long blonde hair. And, now he's got more hair growing out of his ears than he does on top of his head. I mean, that's how long Scott's been doing.
Your hair looks fantastic, Ken.
Yeah. It's because it's a wig.
Got a while back. It's been fixed.
It's a wig now. It's just turning gray. It's so old.
Yeah, we're no longer white papers. We're one pagers.
So. Yeah, one pager. See, I just can't change my verbiage anymore.
Okay, the speaker's race, it's been resolved. We have committees being assigned, and we've already mentioned we have a lot of new members. And so we get our committee assignments. I mean, what was your thoughts when we first got our committee assignments for our committee? I mean, it was pretty much a lot of new people. Cory?
But yeah, we had a lot of new committee assignments, so we had a lot of people we had to go visit, and a lot of them that we haven't really visited with before. So yeah, it was hit the ground running and go fast.
How would you describe the dynamic of the committee when we got the committee assignments?
Okay, big changes, big changes. Obviously, again, going back to the speaker's race. One of the major things was, were we going to have strictly Republican chairman? And so really for the first time in the last 20 years, probably, since I've been doing it, we have always had a Democratic chairman of criminal jurisprudence and the other committees. For the first time, we had a Republican chairman. I think that was a new dynamic.
Yeah,
obviously, we had a vice chairman that was Democratic. I mean, Mr. Chairman Smithy is a long tenured member, respected member of the House, but he has never sat on any of our committees before. So again, as we go back, it's all about education before the session and once those assignments come out, trying to bring them up to speed on the topics and the issues that we're going to have to address during the session.
Well, and one of the dynamics we had from last session was Moody was the chairman of the committee last session, and that had a huge impact on bail bills getting out of committee and to the floor, and they got delayed. And then, you could argue there was an agreement. You could argue there wasn't an agreement. There's all kind of rumors that went around. Lieutenant Governor even told us one of the things from the end of that session, but I don't want to get caught up in that. But what I want to say is, so he was still on the committee, so he brought a lot of that past information. And I would say that a lot of people, it was my concern, would look to him and say he's the expert on bail issues, which I don't think we would want in a lot of situations.
I mean, I have an immense amount of respect for Speaker Pro Tem Moody. He really does understand a lot of the issues that go on when it comes to bail. And he is a wealth of knowledge. So yes, when it comes to bail and criminal justice issues, and he is on that committee, there are a lot of people that are going to lean on him for his knowledge and his years of expertise. On the committee, he's been chairman of the committee before. He's been vice chairman of the committee before. He's been a member of the committee before. And so therefore, I think he's the only one that's been on the committee. Let me see. That's ever been on the committee.
Mm-hmm.
And you have to understand, criminal jurisprudence is a committee that hears the most bills of any committee during a session.
Well, and he's Speaker Pro Tem, so he's
Yeah.
got to have a close relationship with the Speaker, Burrows.
Mhm.
So, Cory, talk about how do we educate a committee once we find out who they are?
Well, the first thing is we show up to their office and meet with their staff.
Mm-hmm.
Try to get us a meeting to where we can hopefully speak to someone that will take our information and pass it along. Because a lot of times we don't get to meet with the representative, right? We do sometimes, but a lot of times. But what our main thing is to get in there to make, once again, that relationship, to speak to that person and let them know where we're coming from. But like y'all said, that Moody he's a wealth of knowledge. He does understand that. He's been around with criminal justice for quite a while. And going in and speaking with everyone that we can definitely helps to pass along, our side of, what we need to do, because, some of them actually don't see exactly eye to eye with us. Like Moody sometimes doesn't see eye to eye with us. And so we do need to get in and speak to the other members of the committee. We had Loudermilk, that was an ex-sheriff that we spoke to several times.
And we worked with him when he was on the Sheriff's Association.
Absolutely. And he was a great wealth of knowledge too, because he sees the criminal justice side from a sheriff's standpoint. And we see it from, basically we're close to what he does too. So, in meeting with all of them, it does help tremendously.
Well, by the time we're going around and meeting committee members or we're going down to their offices, we also have bills that have been filed. And so we have companion bills on the Senate side and on the House side. We still have the same bills filed on both sides, and they start getting assigned to committee. And I think Scott's already mentioned that we did have a meeting early on, and I think you were there for that meeting with Chairman Smithy about the various bills. Talk about that meeting with Smithy and his staff.
That was a very good meeting with Smithy and his staff. If I recall, was it Smithy's staff that we walked in and they were all, I guess, pro Second Amendment? Everyone was carrying. Is that the same office we went to?
Oh, I don't remember. I don't remember that. Looks like we were all three there.
Okay.
I mean, that was an interesting meeting because from my perspective, we were speaking the same language with staff, his chief of staff, or the point person for the bail issues. But I think we were in agreement on a lot of issues, and Smithy was there, but I think we learned a lot about Smithy and his leadership style from that meeting and going forward.
Well, I think when it came to the bail issues, I thought he understood very well that these were Senator Huffman's bills.
Mm-hmm.
I think you get that, but they're big bills, and we'll get into those in a second. He's extremely smart, and a savvy politician.
Well, I thought this session was a big was different than previous sessions because it seemed like a lot of the negotiations that were taking place over our bills was going on way above committees, um, I mean, staff, committee members, chairman. I mean, they were like, it seemed like, I mean, we were told about a meeting between the governor's staff, the lieutenant governor's staff, and the speaker's staff, and that they were making decisions about how to go forward. And I don't know if we've ever had that before. Have we?
Well, not to my knowledge. I mean, this is the first time someone actually came out and said it.
Mm-hmm.
These are all things that are happening above our pay grade. Um, and when I say our pay grade, we're talking about chiefs of staff and
Mm-hmm.
authors of bills and things of that sort. Um, these are, major pieces of legislation that, like you said, speaker staff, lieutenant governor staff, um, obviously Senator Huffman and her staff. And so there's a lot of things that go on, we play in the minor leagues and they play in the major leagues.
Well, one of the earliest meetings we had was with the lieutenant governor's staff. I mean, we met with him, but we also met with his staff. And I don't know how to describe it other than we just hit it off with his point person in his office for these issues. And I think we ended up having a really good relationship with her uh, throughout the session. And if we wanted to know what was going on, I think we would check with everybody, but it seemed like her information, I'm not going to say was the most accurate, but we end up getting uh, relying upon that information more than others. Do you agree, Cory?
I do. I believe we were able to pass along our information and the facts that we know, and um, in my opinion, they were being passed along to the respective people that needed to hear it. So, yeah, we did have a good relationship.
Well, there was, I mean, it's really hard when the negotiations are taking place above everybody at the lieutenant governor level, the governor level, and speaker level, and kind of being mediated by Huffman and Smithy and their staff. And I mean, I remember we were given this a little sheet and we are shown a sheet and saying this is what the Democrats are asking for, and I was like, everything on this list we can't agree to. And it's like you don't even know who to talk to in that situation. How do you make your point known when there's the one people you need to talk to are not accessible? I mean, how do we
You,
do that, Scott?
you just keep rattling the bushes. How many times do we hear this session? We're not at liberty to say.
Yeah.
Okay. Haven't ever really heard that before.
Mm-hmm.
I
Mm-hmm.
mean, normally staff is a plethora of information. Um, but that just goes to show the negotiations that were going on. That the overall were like, we're not at liberty to say,
Mm-hmm.
until we get the okay to share information, that's when they're going to share information. And I mean, we understand that. I mean, these are
Oh,
high level stuff.
yeah.
Very
And
tight-lipped.
one of the things I was, started saying early on in this session is we do not want to get to a conference committee. We want the compromise to be out in the open, and then the other chamber agree to it, because I was worried, we come out worse in a conference committee. I thought than we would if the compromise was made at the committee level, knowing that the other side would confirm. And that's really kind of what ended. I mean, that's not what happened. It wasn't, or that is what happened, but it wasn't because I said this is what we wanted. It's just what happened. And I ended up thinking it was better for us than if it had gone to a conference committee. I mean, Cory, do you agree with that? Or,
Yeah, I agree. It's better if we don't have to go through all that, honestly.
I mean, Scott, what do you think? Because it seems like when you get to a conference committee, a lot of stuff can happen behind closed doors that we really, I mean, and it's very short time.
I mean, not that we're ever in control of anything, but
Yeah.
obviously when it goes to a conference committee, I mean, no one's in control.
Yeah.
Um, Politics plays a lot into that. Um, moxie, it's my way or the highway. And you can never bet on that. And so, yes, when it goes to conference committee, all bets are kind of off.
Well, I want to talk, I mean, we're going to talk about some specific bills, but before we get into that, let's just talk about something in general for a moment. When we're right in the middle of the fight in a legislative session, a lot of times we hear things and we hear this is what's happening, or we hear that's what's happening. And some of it's good, some of it's bad. How do we navigate? How do we figure out what is true and what is false in the session? Because I think that's the hardest thing to navigate. How do we do that?
Even though we've fostered these relationships, I think that's where we really rely on our lobbyists. Um, there are things that people will tell our lobbyists that they won't tell us.
Mm-hmm.
And we have to really rely on them and take our lead from them in those sorts of situations.
The point I would make is I think trying to figure out which information is good information is one of the most difficult jobs that we do. And I agree with Scott that we have to rely upon our lobbyists to a certain extent. But we also, I think what we're really good at, or one of the things we're good at, is just scattering and going and talking to people and then coming back and comparing notes. And then we start making a list of all the things that we've heard over and over again. The more times we hear it, the more likely it is to be true. And I thought that we did a pretty good job of this session getting to what we thought was the truth and what we speculated was the truth. And in the end, it turned out to be correct.
Yeah.
All right, let's talk about bills. We had 3 constitutional amendments that were proposed at the start of the session by Senator Huffman, SJR, because constitutional amendments are joint resolutions. They have to pass by 2/3 vote in both chambers to be able to go up to the voters. And if it passes, then it gets added to the Constitution. So we have SJR 1, SJR 5, and SJR 87. One of them, the first SJR 1, dealt with the constitutional amendment that if you're an illegal immigrant and charged with certain crimes, then you're not eligible for a bond. And the second one was just an expansion of preventive detention for certain crimes. And then the third one was an additional constitutional amendment that said if you have a criminal history of these crimes and you're charged with a new crime, which is on the same list, you're not eligible for bail. Let's talk about the politics of that. When we were looking at, we're like, well, the second one, the expansion of preventive detention would probably be the easiest one to pass, and maybe the other two would have difficulty. But we met with Smithy, and he's like, oh, everybody's telling me that the one on illegal aliens is going to be the easiest one to pass. And I think that ended up being the most difficult one to pass. But let's talk about the politics of a proposed constitutional amendment when they're looking at these three things. Scott?
Well, obviously, the biggest hurdle is 2/3.
Mm-hmm.
I mean, we already, to go down the rabbit hole, obviously in the Senate, the 2/3 threshold is not as difficult to reach as it is in the House. So, when it gets out of the Senate, gets to the House, the process starts all over again. I mean, and that's where really politics and other legislation, other people's wish lists of things to get done enter into the equation more than it does on the Senate side.
Well, but when you think about the previous sessions, we haven't had, I mean, there's been a constitutional amendment to expand preventive detention proposed in the last, 4 or 5 sessions. And it's never gotten, I think it got the votes one time in the House, and then they changed it in the Senate, and they didn't get the votes the second time in the House. So other than that, we've never have a constitutional amendment that got 3/4 or the 2/3 vote in the House. So, I mean, I would look at it and go, this is going to be very difficult. I mean, the politics of this makes it very hard. I mean, Cory, what was your perspective when we started the session with these three proposed constitutional amendments?
Well, I think our group sat down and I, I think we were pretty much in agreement on some of them. Like, there's not as much a chance. Like you were saying with Smith, he was saying that the immigration thing was going to be easy to pass. I think several of us were like, I don't know about that. Not right now. Well, not with the climate in political field right now. I mean, there's a lot of animosity amongst everybody about all that. So I think a lot of the animosity about the whole immigration thing, it wasn't the right time. Maybe later, but
I mean, when we look at all three of these bills, I mean, three of these constitutional amendments, you would look at the second one, which is the one that has been proposed many times. You're like, it's never passed. And so you look at the other two and say, if that one doesn't pass, these other two are not going to pass. But
The initial bill got passed. I mean, I forget the number, but
SR 5.
SJR 5, you know, I think when we went into the session, when we started talking about immigration, which is a national, issue, it's easy to sit there and go, the immigration issue is going to be easy. If you're here illegally and found to have committed a crime, you should be held without bail. I think the finer points of the bill is what held it up. You had to talk about, DACA people. You had to talk about people on visas, and I learned a whole lot about visas that I'd never heard of before during that. And really, SJR 87 was a last 2 weeks of the session bill that the governor, I believe, felt that the preventative detention legislation didn't go far enough.
Well, that was one of those things that we were hearing in the negotiations, that they had this SB 9, and the governor didn't think it went far enough. SB 9, SJR 5, the governor wanted to go even further.
And he did.
And so he filed SJR 87. And remember, they tried to do a floor amendment, little did a floor amendment to add it to SJR 5. And the only reason why it wasn't added is because of a point of order on that it wasn't germane.
Right.
And I wonder if he had gotten that added on the floor, if it would have passed, because ultimately SJR 87, when it caught up and got voted on the last few days of the session, it only failed by 1 or 2 votes in the House.
I don't recall.
It was
that. Yeah, I mean, that thing flew through the Senate and got to the House and got, ran through, and before you know it, there's a hearing and it's out and it's on the floor. I think my personal feeling is that the House felt that the body felt that they had done enough on bail reform for that session, for this previous past session, and they didn't want to go any further.
I do think that was the arguments that were being made. We've already passed this. And they would say this is included. The court has the discretion, and so you just don't need any more. But it's still, I mean, SJR 87 only failed, I think, by 2 votes. One, if you thought that the speaker would have voted if he needed to vote to pass it.
I think it'll come up the next session again.
Yeah, I was going to ask, do you think, Scott, that that's going to be an issue coming up in the next?
I don't,
because it depends on what the climate is, but yeah.
Yeah, I mean, I think that you're going to see both of them come up again. I know we're getting ahead of ourselves here with prognosticating.
Well, I think that depends on what happens between now and then, because I think Harris County is setting policy. Is the reaction to what Harris County is doing is the cause for a lot of what's going on in Austin relating to bail right now, and so we'll see what happens in Harris County over the next year and a half. and how that will impact bail policy at the next legislative session. Let me ask you a different way. Because of what's happened in the country on immigration policy in just the last 2 months, if they voted today on the SGR1 dealing with illegal immigrations, do you think the vote would have been different if it was today instead of
No,
3 months ago?
no,
I don't think so either.
no. I think just from a national perspective and the way that we're dealing with immigration, I mean, I can only speak to the jurisdictions that I'm familiar with. Cory, maybe you can talk about yours, but majority of the time when I see someone in jail with a Spanish surname, I mean, they're getting them run through ICE. I mean, for the most part, if they're here, if they feel that they're here illegally, they're putting an ICE hold on.
Well, I think that was one of the arguments they made on the ICE
Yes, it
hold.
was.
They can already consider their immigration status, so you've already got what you needed in SJR 5, and so the Democrats weren't going to agree to that. And I think the vote, I mean, they weren't even close on the illegal immigrant constitutional amendment. And so I kind of agree. I think if in what's happened since the legislative session ended, if the vote was today, I think the people voting against it are just as entrenched as they were then.
Absolutely.
I've, in my opinion, all the people that were in favor of the was it 87 SB 87 with the
JR
SJR.
87, yeah.
that were going to be held for without bail. I think we all discussed that before. We're like, there's no way that's going to pass as is. Um,
Well, they got really close. Got
Is
really
that
close.
is it possible? I mean, there's a lot of things of just being holding someone without bail. You know that's just going to be an issue. No matter if they're
Well,
illegal.
that was one of the issues that we talked about in our meetings before the session started. And it wasn't us bringing it up, it was other people bringing it up to us on whether something like that would even be constitutional. And it wasn't the people that opposed it that were bringing it up to us. It was the people that supported it that were saying, I mean, they were kind of telling us we have questions about this. And I thought that was interesting because I don't think you heard anything like that from those same groups once it was filed and they were proposing it.
I
You know,
spoke
when
to
it,
several DAs in my jurisdictions that I brought bail in. They were like, I question the constitutionality of that.
Oh, that's a good point. I mean, that's a recurring theme that we heard early and then we talked about, but during the session, I don't think that came up from the proponents. It came up from the
No,
opponents.
I mean, I think that that came up so late
Hmm.
in the
late.
session.
You're right.
I mean, it literally butted right up against the deadline in the House when it finally
Oh
got
yeah,
to the House.
that's true.
And
You're
there
right.
had been so much, I'm not going to say animosity, just
Well, but the
bail
end of the
reform
session,
has,
nobody's talking to each other from the different
no,
factions
No,
no.
anyway, and so they're already so mad at each other, and so we always said, once we get to the end of the session, it's harder to get something passed because everybody's mad at each other.
True.
yeah.
Okay, we've got three bills that I want to talk about a little bit because one that we need to highlight for our industry, which is House Bill 2697 by Anchia, and then we've got SB 40 and SB 9, which were Huffman's bills that passed. But I think probably the most important bill for the bail industry is HB 2697, and I don't want to lower the importance of SB 9. It's a huge bill, and you could spend a lot of time talking about it, but I don't know how much it impacts the bail industry. We'll probably highlight a few things, but I mean, talk about HB 2697 by Chia, Scott, since you're from Dallas and it was being proposed
I,
by the Dallas DA's office.
I am. Well, 2697 has to do to prior, you have to, prior to the filing of a motion 1719 motion, which, as we all know, is a motion to surrender a bond.
I call it it's an affidavit requesting a warrant.
Correct. And you have to notify the prosecuting attorney of the county who is in charge of that case that you are going to be filing that motion, in
Okay,
essence.
So in 1719, we already give notice to the defense attorney if the defendant
Yes.
has one. What
Correct.
2697 added was for felonies, we have to also give notice to the prosecuting attorney.
Right.
I mean, how big a deal is that, Cory, for your practice?
Actually, we just had a bail bond board meeting Wednesday, yesterday, and I was talking to my district attorney about that. He doesn't think it's a problem. And I write in several counties that are smaller, that to them, that's not an issue. But our question that we were discussing was the issue that came up that made that we need to file a bill for that. You know, it's going to be the bigger counties typically that are to a blanket thing over the state of Texas. So he was like, why do we have to worry about that? Honestly. And I can see some issues with it, and Scott may be able to go into it a little more detail than I can because, you know, Dallas County, El Paso, Travis, Houston, you know, stuff like that. Maybe they have an issue with that. But a lot of these smaller rural counties, which is most of Texas, it's not an issue to them.
Well, I would say we met with the attorney from the DA's office in Dallas that was proposing this. And one of the things that we talked about, I mean, that was the first thing we talked about is why are y'all wanting to get all of these? And, you know, and who do we serve? The statute, you know, your proposed amendment says prosecuting attorney. And, you know, her response was, well, prosecuting attorney is the sitting DA. But, you know, since the bill is passed and it goes into effect in just a few weeks, Dallas has kind of done an about face. They don't want the DA to get all these. They want it to go. They're setting up a special email address for these to go to. But I question whether that's even proper. If we're going to give notice under Rule 21A, I think we still have to give notice to the sitting DA and then send a copy to this email address.
Well, our question between and me and the DA that I'd spoken to was, what is the time frame? 2-3 minutes before, 2 days before, a day before? When are we doing this?
Just as prior to the filing of it.
So,
well, but I mean,
if I can delay that filing, I can do it within 5 minutes. Boom, it's done.
Well, what if we just e-file it and we get them served with it? Isn't that before?
That's not before because it's being filed at the exact same time. That's what
but isn't it before it's been presented to the judge?
Not if you're presenting it to the judge at the same time. With e-file, right?
Well, what if you e-file it, but then you go before the judge? Hasn't it been given? You've given notice. How is that not notice?
And that's the question.
And we're going to have that fight or the discussion with counties. We're going to, I mean, my advice to bondsmen is contact your DA's office in your county and say, how am I supposed to serve this on you?
Yes.
Ask them, how do you want this served? Scott?
I think that's as we spoke with, you know, Representative Nchia's office about this, and we're like, this is really an open-ended kind of a bill. There's no direction as to, like you said, who do we give it to? How do we do it? They leave it open-ended to let each county determine how it is that they want to handle it.
But that's not what the DA told us. She said the prosecuting attorney is the elected DA. That's who you serve. That she said that term, prosecuting attorney, has been defined by case law.
I don't deny that. Okay. But my discussions with her, I'm like, so how do we do it? And that was her response was, well, we're going to set up an email for the district attorney and you just send it to the district attorney. And I'm like, I'm sure they're going to love that.
Except for that's not notice. That's not proper notice under Rule 21A, which is what they're saying we have to do because you don't have proof that you sent it to them when you just send them an email.
again, this is what happens with legislation in Austin.
Fixing a
There's a
problem that we didn't have a problem of.
there's an action and a reaction.
Mm-hmm. Well, there's
Okay.
unintended
There was an
consequences to
there was
everything.
there was
And
an action in Dallas County, and so now there's a reaction.
well, and what
Okay.
caused this is they had a case that had,
More
a
than
new
one. Yeah.
crime committed. And when the new crime was committed, they reviewed his previous criminal case and they found a request for a warrant that was not granted. And so the DA's office took the position that if we had known about it, then we could have joined in asking the court to grant the request for a warrant.
That
My
is true.
problem was you don't have the manpower to review these and decide which cases you want a warrant on. I mean, you're going to do this is going to end up being a paper shuffle, and I predict that in 2 years it may be like when we added misdemeanors to TCIC, and then 2 years later
Hmm.
they took it out. So I could see this being removed in 2 years because DA's going, I don't want this information.
Well, yeah, more work than they asked for.
Yeah.
Yeah. So we discussed that I did with my DA before a board meeting, and he was like, "We don't have that problem."
Okay.
Some counties
So
will.
maybe that's the answer. In the majority of our counties, we're not going to have that problem. But in our urban areas, you're going to need to know who do you serve. And that may be in addition to serving the elected DA, because that's what supposedly the statute and the case law requires. My
Within the
concern is
school.
if we're setting up a trap for defense attorneys to use under 1704.207 to ask for part or all or part of their premium back. And I don't want to do anything that gets us near that. There's a whole reason why, there's a whole argument about why it doesn't. But if we have one hearing on that argument, then I'm going to be upset that
In the
we've
right
added that.
place, in the right jurisdiction, that argument could be a problem.
Well, the other there's two more bills that we could talk about, and the first one's very short. It's SB 40, and I just want to highlight from SB 40 I think the importance of the bail industry as a resource, because the bill that was filed was so that government funds cannot be given to charitable bail organizations to post bail for defendants. There was an allegation from Harris County that was being done. They had a whole bunch of documents. And then when we came in for a hearing, they gave us copies of it. We looked at it and immediately said, this isn't what you think it is.
We were in the cafeteria at the Capitol. We were all sitting around our group of task force. And that's when a person came up to us and said, "Hey, this is a situation we have with cash being given out for the defendant stuff." And Ken threw out there, "These are cash funds that were posted. They're just giving cash back. These aren't cash funds that were given."
Well, that was our speculation. And so
Yeah.
we immediately
Well,
pulled
you
it.
looked into it and found out that that was true. That they weren't doing that.
So we pulled up the case numbers. We're there in the cafeteria on our phones and confirmed that there were orders on those dates ordering the
But that
return
was
of the
that
cash
was
flow.
coinciding with the money from the county being given to people to be released for bail, and that wasn't actually happening, right?
Yeah.
If you want to clear that up, you can.
No, that's right. And I just think, the bill still passed. It still has a great position.
Passed,
It's
but it
still,
never happened.
we don't want that happening. But I thought, that shows the importance of the bail industry as a resource. So there was a misunderstanding, and we cleared that up very quickly. And once we cleared it up, they asked for their papers back, and we more than happy to give it to them.
I think what came out in floor debate, especially in the Senate, was because they brought up this issue, or possibility of this issue, and then the sponsor of the bill said, "Well, we're wanting to make sure that this just doesn't happen in the future."
And it shouldn't. That should not be an issue. That should not be something that taxpayers are paying for the release of bail for people. That's a thing.
Okay, so let's talk about SB 9. That's the Jongamonga bill. That's the fix or the tweaks to SB 6 from two sessions ago.
Let's do it.
And SB 9 is a huge bill. I mean, really, because it has parts that go into effect September 1 in just a few days or a few weeks, then parts that don't go into effect until January 1, and then parts of next year, and then parts that don't go into effect till April 1 of next year. It's kind of like the original SB 6. And there's some parts of this bill that were added at the last minute that I do not like. But overall, I think it's a very good bill. But from the bail industry's perspective, what do you think is the thing that will impact the industry the most? I mean, I think it's changes in additions to crimes that are not eligible for personal bonds. What about you, Scott?
Sure. Yeah, sure. I mean, I think what it focuses on is previous criminal behavior
Hmm.
and or criminal behavior that you may be out on bail now and previous convictions and whether or not you're eligible for bail at initial arraignment and who can set that bail.
Hmm.
Obviously, the judge that has if, previous knowledge of your criminal history um, that those cases will be assigned to should be the one that sets that bail. Um, and so I think we're just trying to look at more accountability from the judges and not magistrates or JPs setting those bonds without knowing that prior criminal history.
Corey, what do you think the most important part of SB 9 is?
I think tackling recidivism is a part of it, adding some of those other charges to it. Um, I hate to call out like the whole rogue judge thing, but there's a lot of judges that will just set a bond, let someone go, let them out, and then boom, they're right back in with the same thing or done it 2 or 3 times before they get picked back up.
Well, I mean, you would have to say that that's the perspective of the legislature because they just limited in this bill Chapter 54 magistrates, who I would say there's like 30 counties that they are hired. That's pretty much what they do. They arraign and set bail. They
Yeah.
arraign and they set bail, and they do the initial appearance all day long. Well, now there's a list of charges. It's small, but it's a list of charges that Chapter 54 magistrates can no longer magistrate for. And so the counties, and that part goes into effect in just a couple of days.
Yeah.
Well, I mean, I think you should for our audience, what is a chapter 54 magistrate?
Well, I mean, you look at Chapter 54 of the Government Code, and so any county that wants to hire magistrate judges to work in their county, they have to get approval for that from the legislature. And so in Chapter 54, there's a section for each county that wants magistrates or associate judges or whatever you call them under Chapter 54. And so it lists for each county what their qualifications are and what they can do. And so when that bill was originally passed, or when it passed the House, they limited it to only apply to probably 10 counties, probably less than 10. The largest urban areas, probably targeting Harris County because they think they have the biggest problem. And I would agree they do with their magistrates being caught in a political fight over the far left and what the legislature is asking them to do. And so, but on the floor, members would rise up and say, "Well, I want this to apply to my county. I want this to apply to my county." So they took the limitation off, and so it now applies to all Chapter 54 counties. And I think we have provided a list, internally talking about the all the counties that it applies to. But we had our last school maybe a week and a half ago, and for the bail, we had a Chapter 54 magistrate there, and she made a comment that her county was caught flat-footed. They didn't believe that that was going to be applied to them, or they didn't have any idea that they were going to be having restrictions on what the magistrate that was there, what she could magistrate going forward and going into effect in just a couple of weeks.
That goes to TDCAA. I mean, much like we are tasked with educating our bondsmen on changes in the law,
Mm-hmm.
um, And with all due respect to the magistrates and judges that are around the state, um, they may not know all the changes that get
Hmm.
made during a session that apply to them until they go to some of these continuing education classes and they go, whoa, that's not how we handle things in XYZ County. Does that apply to us? What can we do? What can we not do?
And you may be
It's
a year later.
Yeah.
Yeah. I
Well, a
mean,
couple of the small changes uh, that are set out in SB 9 is any final judgment in a criminal case going forward after September 1 has to set out, was there a failure to appear?
mhm.
And if there was it willful? And we're kind of looking at that. That was the willful part was added at the very end. And I'm encouraging judges. I know that OCA is supposed to suggest a form, but I would be saying, is it willful? Is it not willful or unable to determine? Because how many defendants are going to stand up in front of a judge and said, yeah, judge, I didn't come to court and I intentionally did not come. I don't think anybody's going to admit to a willful failure to appear.
Okay, is that any different than a defense of a defendant missed their court date at no fault of their own?
Yeah, it's the
Okay.
opposite because
It is. It's minutia. That's what I'm
well,
saying.
but,
Willful, you
Well,
know,
at
well,
what
but
point
if
does
they
it
had
fall
an
into the I didn't
emergency,
know?
go ahead, Cory. I didn't hear you.
I said, at what point does it fall in? Well, I didn't know. Well, I didn't
Yeah,
know.
well, yeah, that's not willful. But I mean, do you think they're going to admit to willfulness? They're going to say, "Yeah, I did it. And I did it intentionally." I don't think they're ever going to admit that.
I wouldn't.
are they ever going to be asked that?
Well, I think they will be, but
Well,
does the court even have the ability to compel them to answer that whether it was willful? I don't think they can. Don't they
Take
have a
the fifth.
right to not answer? And if they did answer that, could they then file bail jumping charges on them based upon that answer?
you have too many
Well,
excuses.
boy, man, you're going down a rabbit hole
Yeah,
there. I mean, we
probably
don't
not.
know.
Probably
But
not.
I
but
mean,
it's a valid rabbit hole, honestly, if you think about
it
it.
is.
That is a
No,
valid rabbit hole.
I agree.
Well, but aren't we now going to have in our business to have to tell our clients that if you have a failure to appear, they're gonna ask you, and you're gonna have to prep them, so they'll know what to say. I mean, I think that's one of the things we may have to ask on our laundry list. I mean, if we
You
have a
know,
bond reinstated,
Well, then that
well,
falls into us of being
and if the bond's
moral,
reinstated,
our
did you have
moral
a failure
right
to
as a
appear?
bondsman.
Yeah.
Are we morally being,
There's
I,
one change though. There's so many changes here, and there's changes into the public safety report. What has to be in it? There's minor changes to that. There's also changes that the prosecutor needs to have access to that report if requested. Those are all put off, so because those require technology changes, and so that's put off until either January or April. But one of the changes I really like, and it may be small, but I think it's really important, is once someone pleads guilty to a certain charge, they cannot be released until sentencing. They have to be held. How many times have we had cases where someone pled guilty and they're like, okay, well, we're going to give you 2 weeks to go get your affairs in order and then come back. And then they're like, oh, well, we don't want to go to jail for 20 years. And so they
that's the
run.
last time you see him.
Yeah.
Yeah.
I had a situation in one county where, uh, I thought it was nefarious. They didn't like my bondsman, and so they took like his three biggest bonds and said, "Okay, we're going to send it. We're going to send you in 3 weeks, and it's going to be really long, and it's going to be really bad. But you come back." And the guy just came back, thank God. Or each one of them did.
You've got life in prison. See you in a week.
yeah, unfortunately, I've had it happen twice, and I mean, they already know what they're doing, and they've been on bond for 3 years already, and they say, well, you have 3 weeks to get your orders, you know, your affairs in order, I guess I should say.
Mm-hmm.
And I'm
Yeah,
like,
3 years
you
to
had 3 years to do that.
Yeah.
I mean, I think it's a good thing. You know, you know, as a judge, and um, just as a human being, someone knows that they're going to jail for 25 to 50 years or whatever it might be, you know, they're not going to get any more time, skipping out on a sentencing hearing.
Yeah, I think it's a good thing. I think once you're sentenced, you should be done. You're going into that day knowing what you're going into.
We have let's talk just kind of as we're winding down to one of these recurring issues we have every session, and that is how much, we have a tight knit group. So how much information do we share? Because we have this competing interest inside of our committee and our group. We have one group or one subgroup that's like, we're not sharing anything. Loose lips sink
Sink
ships, and
ships.
Ken's got loose lips, or
Amen.
so and so has got loose lips. And then we've got this other group that says, look, we've got people that are our coalition that are important to us, and we've got to keep them informed if we want to get money for them or from them. And so how do we fight those competing interests? Cory?
Trust.
Oh, that's very good. I think that's very good.
You should
Scott?
trust.
I mean, I'm going
Yeah,
to tell
I
you,
mean, I mean,
Tillman, who did this before you, was very much on the we're not sharing information.
I'll tell you what you need
well,
to know. We need to know it type of
Mhm,
thing.
mhm,
And I will be honest with you. You be honest with me. I think it's a trust thing. It
mhm.
totally is. And I think we have that with our coalition, with our sureties, with our bondsmen, with our on the legislative committee. It's trust because we can't just go out there throwing things around willy nilly, hoping that we keep it amongst ourselves because there are things that do not need to be out there.
Scott, you and I don't always agree on this issue. So what's your thoughts?
my thought is I'm always right.
Wait, where's your
No,
wife? We need to
no,
ask your wife
no,
that.
no,
I
no,
don't
no.
think she would agree with that
I think
wholeheartedly.
when we get to those sorts of issues, let's be honest. We have a group of people that go down and deal with this stuff on a weekly basis, not just during the session. I mean, this is something that we do year round during the interim. And I think when you're talking about issues, we're talking all encompassing, um, meaning we get this question, what are you going to do about it, from our constituents, from our fellow bondsmen? And when we talk about strategy, um, we talk about that between our core group of people that go down,
Hmm,
that
hmm.
know our strategy and know what we're going to be doing. Um, and we've been pretty firm on that, and I know that that probably is a feeling of some hard feelings from probably members of our association. Um, but like you said, loose lips sink ships. You can't, you know, in a football game, you don't tell the other team what play you're going to run before you run it.
You
Okay.
don't?
So no, 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 it's
Double
not
field
double
goal.
field goal.
No.
Not double field goal. Um, and so, it's just, we have to keep those things to ourselves a little bit, and let them play out, because even the situations that we come up with may change at a moment's notice. We may think we know what we want to do about a piece of legislation ahead of time. And as the session proceeds through, things change. It's a fluid situation. If there's one thing you can say about Texas politics and the Texas legislative session, as soon as it's gavelled in, it's a fluid situation. Everything changes on a day-to-day basis.
Minute by minute.
Well, I mean, this session was very different from past sessions because it seemed like a lot of our issues were resolved or stalemated early, just waiting to be,
Mhm.
pushed. But then, like on SB9, when we had a hearing on it on the House side, we go to a hearing, we are expected, are prepared to testify for 3 minutes, maybe 2 minutes. And then we got get there and whatever I said or whatever we said was enough to piss off enough people that we end up getting questions for 45 minutes. I mean, we haven't had that in a long time, but
I mean, I think that goes back to our relationships. I mean, right now, I mean, for the people that are going to be watching this, there's testimony, but there's invited testimony.
mhm.
Um, those are two different things. Invited testimony, you're given a little extra time. As we all know, generally public testimony is limited to 2 or 3 minutes, but when you have invited testimony, you're given a little more latitude to discuss your topic and your issues. In particular, what you were talking about. I believe at that time, invited testimony was given 5 minutes, and you were wrapping up in a topic and what you were talking about, and your timer ran out, and the chairman said your time is up, and a member of the committee said, no, I want to hear the rest of what he has to say.
Mhm.
And that led into another question, another question, another question. All of a sudden, you're up there for 45 minutes. Again, that's about relationships and the people that we deal with that want to hear what we have to say.
Well, in the coming days, we're going to be, publishing a lot of articles talking about these bills that we've kind of done a highlight on going into effect and what the substance of them are and all that. But looking back on this session, what would you say is the lessons that we learned from this session, and what could we do better next session? Cory, do you have any ideas?
Things that we could do better next session. I mean, I think we did a great job this session, honestly, because once again, we were proactive and we were going to talk to people long before the session started, long before anything was an issue, long before we were really on the radar. We just assumed we would be. And so we went in,
Yeah.
we talked to the right people, made the right connections, made, once again, relationships with people that we needed to. And I think that was a great factor in our last session of doing so. As far as what we can do next session, I would say continue to do what we did. Start early, start now. I mean, it's to us and the legislative committee and legislative task force, as I like to call it. It's always legislative session. We're always
Scott, you and I have
working.
talked about one of our biggest surprises from the session was Representative Little. Talk about that for a minute.
Well, Representative Little was a freshman this session. He was on our committee, extremely smart.
Mm-hmm.
A lot of smart people on that committee. I mean, it just blows me away. It really does. And I think as a freshman, normally you're kind of relegated to the back of the pecking order. I think Representative Little moving through the session, both through committee on the House floor, represented himself very well. And by the end of the session, as we know, when it came to SJR 87, he was selected as the sponsor in the House. I, I we have met with him. I don't know him that well. I want to get to know him better. He's a very smart individual, extremely smart.
I thought he was, I mean, I think we even referred to him at one point as the quiet assassin because he would be very quiet. And then when he asked a question, it was like a
On
dagger.
point.
On
Yeah,
point.
he's always on point.
In fact, we've even commented, how long will he be there? He's a rising star. So how long is he going to be in the House of Representatives?
Probably not very long.
Yeah.
which is unfortunate for the state of Texas and for the Texas State House or the state Senate.
We're kind of winding up, but one of the things that we hear a lot of is how powerful the bail and industry lobby is. And, I always say, hey, if you want to talk about how powerful we are, I encourage you to talk about how powerful we are because I want everybody to think we're very powerful, even if we don't. Because if you listen to this podcast, you listen to what we do, we work hard. We work hard at telling our story. And what I always say is we have the winning story. We just don't get to tell our story a lot. And so I think the lesson from what we've talked about today is we just work hard to tell our story.
I mean, we go ahead, Cory. I'm sorry.
No, I think we need a bigger platform. That's the thing is our voice. We don't have the Houston Chronicles are going to publish our stuff. We don't have the Dallas Morning Herald or whatever that's going to publish on everything we do. We don't have that big platform that a lot of their opponents do. And I think that's a lot of our push uphill is we got to push uphill.
Scott?
It's all about, we talk about, personal relationships, boots on the ground. I mean, we get a whole lot from the 6 or 7 of us that go down on a weekly basis. We go down there, we go to work, and we're there for 2 days. We come back the next week and pick up where we left off. I mean, we're all leaving our businesses, our families, our wives, our children, sporting events, proms, graduations, whatever it might be, to go down and tell our story. And that's what we do. And we do it a lot better than a lot of other third-party organizations.
Agree 100%. We step out there and do all this on our own.
Well, another session down. I mean, we've gotten 2 special sessions, but there's nothing bell related on either one of those. So far,
Yet,
I know so far.
Yep.
And so we're kind of sitting on the sidelines now, waiting to see if, what we've heard is maybe one or 2 of these constitutional amendments that failed might be added back on. But I'm not sure. We don't like to we don't like to predict before something happens. I always like to talk about what happened afterwards. So I don't think we should be talking about if that happens, what will happen. But I'm not sure a lot has changed since the session.
if it does, we'll be ready to tackle it if it gets on a special session.
If it gets on a special session, we'll be down there. And in the middle of the night at 2 a.m, I will sneak into Scott's room and I will raise the temperature.
Pick up the AC.
And then I will sneak back into my room, giggling like a little girl, and I will be.
As you always do.
I will vouch for that. I've seen it.
Well, before we go, I just want to say this last thing. So, my oldest daughter just announced that she's engaged and she and her boyfriend are getting married. Don't know when yet. So what would be, we're all married, been married for a long time. What's your best piece of advice to Darby and Andres on their upcoming wedding? Scott?
Darby, remember, you wear the pants in the house.
Okay, that's not even correct. Cory?
I have 3 daughters. Okay.
I have 2 daughters.
I told the same thing. I have 2 that are married. Wear the pants in the family. Take control.
Cory?
All I have to say is congratulations. Just run with it.
Hey, all 3 of us, all we have are girls.
Yes.
Cory has
true.
2 girls. Scott has 3 girls. I have 2 girls. So we're all girl dads. But I will tell you, one of the things I did, so they've been engaged for a week and a half, 2 weeks. And so Darby went out of town. And so I invited Andres to go to dinner with me. and while she was gone, and we went to dinner, and he started out by saying, you're very intimidating. And I'm like, well, I don't know what you're talking about. But I told him how,
It's the hair.
yeah, how happy we were that they were engaged, that he's joining our family. And I prayed for him and prayed for Darby. And so I'm not as bad and a jerk as a lot of people think I am, or at least I'm an Old Testament Christian, not, I'm still a Christian.
Yeah.
Okay. One last thing for Darby.
Uh-huh.
Darby, I want to be invited to the wedding.
Oh, she's already
There.
told me that you and John and Mike have all gone to her and said, Ken says we're not going to be invited to the
There
wedding.
you go.
You need to invite us to the
I mean,
wedding.
it's on video now again.
My wife works at the federal courthouse. I told her, I said, do you really want a room full of federal judges and bondsmen
Yeah.
at a reception? Because if we do, I promise you, I'm going to be announcing, Judge so-and-so, your bond is ready to be signed at the welcome desk. Well,
great.
there's lots of joy. We had a great session, lots of family joy, lots of good things to look forward to. Scott, you've already had 2 weddings. Cory, you've got weddings to come. And I'm now at the point, I told my daughter, we'll pay for any wedding you want, or I'll give you $30,000 if y'all elope. And they did not pick that option. Darn it. So
save yourself some money that way.
Yeah, I would have saved a lot of money, I think. All right,
All right,
guys.
guys.
All right.
All right,
Scott,
thank
you have
you,
a good
Ken.
trip. Cory,
All right.
thanks for
Thanks,
this.
Cory.
I know we've been putting this off for a couple of weeks, but it's all Scott's fault. We know that. We all
No,
agree.
it's not. I'm available anytime.
Thank you for listening, and come back for the next episode of The Bell Post.